My name is Robert Carnwath. I'm a former Justice of the Supreme Court, but now an associate member of Landmark Chambers. And I'm delighted to be asked to chair this webinar on a subject which is certainly very important, but one of which I personally haven't had great detailed knowledge other than in connection with one or two cases I've decided in the Court of Appeal and the Supreme Court. The object is really to launch Landmark Chambers' blog on the Aarhus Convention. Now, I'm not the best person to explain to you how that's going to work. Blogs are rather after my time, so I'm going to ask James Maurici, who is our first speaker, to talk about it at the beginning of his presentation. We hope you'll find the presentations useful and interesting, and in case you missed it, the first blog post was published last week and is available on the resources page of the Landmark's website. Now we have perhaps just a few housekeeping points. Your microphones are automatically muted, so you will not need to adjust your local settings. We welcome questions throughout the sessions. Please submit them via text in the Q&A section on the screen at the bottom or top. If you would like to remain anonymous when asking a question, please make sure you tick the send anonymously box before submitting your questions. And we'll attempt to answer such questions as we can at the end of the session. The webinar will be recorded and you'll receive a link to the presentation and the recording shortly after the event concludes. Finally, if your connection is lost at any point during the webinar, you're invited to rejoin the meeting by clicking on the original link once more. So I turn to the four distinguished speakers. They all come from Landmark Chambers. First is James Maurici, KC, who's been in many of the leading cases on Aarhus costs, and I'm not going to list them, but he's appeared a number of times also before the Aarhus Compliance Committee in Geneva, and he's currently acting for the UK government on the Brexit communication to the Compliance Committee. And he was one of the contributors to the Aarhus Convention, a guide for UK lawyers, published in 2015, and he's written and lectured extensively since then. The second speaker is going to be, I should have said James is going to cover the status of the convention in domestic law. The next speaker is going to be Alex Shattock. He, again, has been involved in a number of environmental claims, including Friends of the Earth, the Cumbria coal mining case, and other similar cases, and other cases which I won't mention. He's been involved in a number of cases where he's had to advise and on Aarhus cost protection. He's also a keen interest in treaty law generally and has masters and PhD in public international law. Has been involved in treaty negotiations. And he's going to talk about a guide to the three pillars of the convention. Thirdly, we have Jacqueline Lean, who again has been instructed on a number of matters concerning the Aarhus Convention and has appeared with James for the United Kingdom before the Aarhus Compliance Committee, and has been involved in a number of other relevant cases. She is a contributing author to Coppell's Information Rights on Environmental Information, and she's going to talk about cost protection in Aarhus claims. And then finally, we have Nick Grant, who joined Chambers in 2019 and has regularly advised on Aarhus-related matters and has represented the UK twice before the Aarhus Convention Compliance Committee and involved in other relevant cases. So, and he's going to talk about open communications against the UK. So what we'll do is I'm going to hand over now to James, who, as I say, will say a bit more about the blog and will make his presentation. And then we'll run through the various speakers, all of whom have slide presentations. And so I will not intervene while that's going on, other than possibly to hurry them up. And then we'll have time for questions, I hope, at the end. The idea is they should each have not more than a quarter of an hour to 20 minutes, so that we will have time at the end for some questions. So without more ado, I hand over to James.
Thank you, Robert. Yes, before I get going on my talk, just to say a few things about the blog. Why have we launched it and why now? There's really three reasons. One is, as I hope these talks will further demonstrate, Aarhus has had and continues to have a significant effect on the development of our environmental law, both in terms of domestic cases, but also in terms of the Compliance Committee's rulings that have concerned the UK. Secondly, with Brexit and the government's continued policy of decoupling ourselves from EU law, it does seem to us that going forward, reliance on international law may become more important for NGOs and for other environmental challenges in the future. And thirdly, there is no current awareness resource for Aarhus, and that's what we hope the blog in time will become. In terms of what we will cover in the blog, we're going to look in depth at some of the articles. We're going to look at recent developments in Compliance Committee cases that are ongoing, look at developments in domestic case law that consider Aarhus costs and other matters, look at other conventions that are similar to Aarhus, and also look at the way Aarhus is developing in other jurisdictions, including, for example, Ireland. The second blog, which will be coming out in just over a week or so, is one that I've written and is going to look at the impact and the influence that the Aarhus Convention has had in planning inspector decisions over the last 20 years or so. So that gives you a sense of what we're going to cover. I'm going to move on to my talk. So I'm covering the status of the Aarhus Convention in English law. As we all know, the Convention is an international treaty. It entered into force and was ratified then in 2005. And as you know, in our law, international treaties have traditionally had a restricted use in domestic law unless they are incorporated into our law. And that is, of course, a consequence of our strictly dualist system of law. And it's a result of two principles of constitutional orthodoxy, as they've been called. First of all, the domestic courts have no jurisdiction to construe or apply treaties which have not been incorporated into national law. They are effectively non-justiciable. And secondly, such treaties, unless incorporated into domestic law, are not part of the law and therefore can't be given direct effect so as to create rights and obligations under national and municipal law. So that's the orthodoxy. On that first orthodoxy, no jurisdiction to construe unincorporated conventions, there is a whole line of case law that looks at the fact that sometimes, despite that rule, our courts do have to take a view about what an unincorporated treaty does and doesn't say. And the test that's been developed is a very standoffish test by the court, which is that they have to consider whether the decision maker has taken a tenable view of the unincorporated convention, not whether it was right or wrong, but if it's unincorporated, the most the court can do, the most it can do is look to see whether that's a tenable interpretation. So I go back to 2009 and a decision of Lord Justice Carnwath, as he then was, in a case called Morgan and Hinton Organics, which was a private nuisance case where the Court of Appeal did look at that time, what is the status of the convention in our law? And there were two key points that were made. One was, of course, that it was at that time a fully much not incorporated. So there was no part of the Aarhus Convention at that time which was incorporated into our law. So its provisions couldn't be directly applied. But we were, of course, a member of the European Union at that time. The European Union had ratified the treaty, and there were various ways in which the Aarhus Convention was given effect and could be enforced through European law. And the court noted, in addition, that there are several EU directives which have replicated obligations from Aarhus, and which, in that way, would have an influence and were directly applicable in our law. The position has obviously moved on from 2009 and has become, frankly, more complex. The Aarhus Convention is now part incorporated. I'll look at that in a moment, and part unincorporated, which makes it nice and complex. But secondly, of course, we've had Brexit, and I need to look at that too. So as Alex is going to deal with in more detail, there are three pillars of the Convention: access to information, Articles 4 and 5, public participation, which is Articles 6 to 8, access to justice, which is Article 9. And the status of each of these pillars in English law is now different. And so, as I've said, the position is complex. So dealing with them in reverse order, access to justice. So the Aarhus Convention obviously provides through Article 9 for access to justice, and that has been incorporated in part into domestic legislation in the form of the CPR. And obviously Jacqueline's going to look at this in more detail. But the Aarhus cost rules in CPR 45.41 to 45 only apply to judicial review, statutory review, and Section 289 planning appeals. The provisions in CPR 54.6 for Aarhus Convention claims are again limited to those types of proceedings. The only other reference to the convention in our procedural rules is in Practice Direction 25A, dealing with interim injunctions in Aarhus Convention claim cases. This is the only example of the Aarhus Convention being directly incorporated into our law. And of course, because the rules define Aarhus Convention claims by reference to Article 9, this provision of incorporated international law requires direct consideration and application by our courts. So our courts, in deciding whether a claim is an Aarhus Convention, and will have to look at what Article 9 includes and doesn't include by way of protection. So that's access to justice. Public participation. Here we have no domestic legislation as such directly seeking to incorporate Articles 6, 7, and 8 of the Aarhus Convention. But stepping to look at the European position, if you look at the Commission's website, they say the public participation pillar was given effect by the European Union through a number of directives, but principally the Public Participation Directive 2003-35 EC, but also through various public participation provisions in other directives, including, most importantly, the EIA directive, which obviously isn't now 85/337, though the Commission website still refers to that, and the SEA directive. So just focusing on the Public Participation Directive for a moment, that required member states to ensure the public was given early and effective opportunities to participate in the preparation, modification or review of various plans and programmes that were to be drawn up as listed in Annex 1. And Annex 1 then lists plans, programmes, etc. from a number of directives on a wide range of environmental matters, which I've set out there. And various of these provisions in the directives have been transposed into domestic legislation, and at the moment they are retained EU law. So finally, on public participation, the Commission website also referred to the SEA directive as one of the directives that gave effect to the public participation pillar of the Aarhus Convention. Interestingly, the SEA directive doesn't actually explicitly cite Aarhus in the recitals. It preceded the Aarhus Convention entering into force. Clearly, the directive has been transposed into our law in the 2004 regulations, and so it is retained EU law. But there are differences, for example, between the scope of coverage of the Aarhus Convention, Article 7 in particular, that deals with plans and programmes, and the SEA directive. And those differences are said to be deliberate. They were considered by the Supreme Court, by Lord Carnwath again, in the HS2 case, and indeed they were also considered by the Compliance Committee in the HS2 communication, which is number 101. Finally, Pillar 1, access to information. I mean, in relation to that pillar, the EIR regulations transpose the Environmental Information Directive. That directive was itself enacted to give effect to Pillar 1 of the Aarhus Convention. The EIR are retained EU law. And if you look at this area, ICO guidance, case law of tribunals, case law of the higher courts, relies on and considers at length the Aarhus Convention alongside provisions of the directive and the regulations. So moving on, what's the continuing influence of EU law in terms of the Aarhus Convention? As I said, the EU was a party to the convention, and before Brexit, the Commission could actually use its procedures to try and enforce Aarhus compliance amongst member states. That was something that was referred to by Lord Carnwath in Morgan, and an example of that was the infraction proceedings in Commission and UK, which effectively led to Aarhus cost rules. But what's the status of Aarhus now as a matter of retained EU law? Really 4 points. One is, obviously, there is retained EU law in the form of domestic legislation that transposes directives that themselves give effect to Aarhus. And as I've said, the EIR are probably the easiest example of that. Secondly, there are, as again was noted in Morgan, various directives that have incorporated provisions of the Aarhus Convention. But directives themselves, of course, as opposed to transposing domestic legislation, are generally not retained EU law unless they meet the conditions in Section 4.2b of the EU Withdrawal Act. And on that, see the Harris case, which I think is pretty well known on that. So effectively, the provision in the directive has to be directly effective in order for it to be considered to be retained EU law, or of a nature that is similar to other articles that have already been held by the European Court to be directly effective. And then there are a number of European regulations, so directly applicable European legislation that has been retained as EU law post-Brexit in the environmental field, and which in their recitals say they are to some extent reflecting or giving effect to the Aarhus Convention. I've listed them there. There's quite a range of different things there, from fisheries to pollutant release and transfer. And then fourthly, pre-Brexit case law, so cases decided before we exited the European Union, remain binding on our domestic courts up to High Court level, and indeed the Court of Appeal and Supreme Court may only depart from them in limited circumstances. Why is that important? Well, just to give you one example, the VLK case, the Brown Bear case. VLK was an environmental association. It sought to effectively be involved in environmental proceedings concerning the Habitats Directive, which it failed to do. It appealed and it argued that Article 9.3 of the Aarhus Convention was directly effective in EU law, and that they could rely on it to establish a right to be joined in their domestic administrative proceedings. The appeal court referred the case to the European Court, asking whether Article 9.3 of the Convention was itself directly effective in European law. And the court said that the provisions of the Aarhus Convention were integral to the legal order of the European Union, that they had jurisdiction to interpret 9.3, even though the dispute in the case wasn't actually covered by any EU directive that transposed the Convention. But they held that Article 9.3 was not itself directly effective as a matter of European law. And obviously, as we know, some international obligations that the EU have signed up are held to be directly effective, but not 9.3. But that's not the end of the matter, because they went on to say that you had to have regard to the fact that it was drafted in broad terms to ensure environmental protection. And in the absence of European Union rules governing the matter, it was for the domestic legal system of each member state to lay down the detailed procedural rules. But those rules must, in the normal way, be no less favourable than those governing similar domestic actions, must not make it impossible or excessively difficult to exercise those rights. And then they said this: It is for the referring court to interpret to the fullest extent possible the procedural rules relating to the conditions to be met in order to bring administrative or judicial proceedings in accordance with the objectives of Article 9.3 of that convention and the objective of effective judicial protection of the rights conferred by EU law, in order to enable an environmental protection organisation to challenge before a court a decision following administrative proceedings liable to be contrary to EU environmental law. So not directly effective, but as a matter of European case law, still binding on our courts because it was pre-Brexit, the court should strive in every way possible to give effect to Article 9 in interpreting its own domestic procedural rules. What then is the position where the Aarhus Convention is not incorporated? What is its status? So, for example, when one's dealing with costs in a nuisance case, so not subject to the Aarhus cost rules, or a case concerning issues of public participation, where there is no legislation that's directly applying the Aarhus Convention. How might the Aarhus Convention be relevant, notwithstanding the dualist orthodoxy? And that involves us looking at the potential exceptions to the orthodoxy that you don't look at or give rise to rights arising from an unincorporated convention. And there are broadly 5 ways: as an aid to statutory interpretation, in developing the common law, as a relevant consideration in the exercise of a judicial discretion, through legitimate expectation, and then in human rights cases. And I want to look at each of those briefly before turning to one other matter, and then I'll be finished. So the first of these is statutory interpretation. There's a presumption of compatibility of domestic legislation with international law. So there is a general presumption that one should, where possible, interpret domestic legislation to be in compliance with our international obligations. That goes only so far. If the legislation is clear and unambiguous, then it must be given effect, irrespective of the fact that the domestic legislation is contrary to the international obligations. Those principles are well known. They were stated and referred to directly in relation to Aarhus in the Morgan and Inton Organics case. Secondly, unincorporated treaties may have a bearing on the development of our common law. So developments of the common law are said they should generally be in harmony with our international obligations. Unincorporated treaties can be used to resolve ambiguities in the common law. But again, there are limits to this. One shouldn't, through this principle, use the common law to incorporate treaties through the back door. So this is another way in which Aarhus may change our law. It may influence our common law through this principle. And I would just ask you to note, this is something I want to cover in a future blog. There are cases where Aarhus has been referred to and relied on by the court where the case has nothing to do with the environment. And Compton is one example of that, which is a case about hospital closure, not planning related at all. And I think it shows the spread and the potential influence of a convention like Aarhus beyond its actual scope in terms of environmental. And as I said, I'm going to cover that in a future blog because there are more examples than that. So the third way in which one can use unincorporated is judicial discretions. Effectively, judges can have regard to the convention. They can have regard to it in exercising judicial discretions. Again, there are limits to that. The Venn case is a good example where the CPR had not extended to a particular situation. The court said it shouldn't exercise its discretion to extend it beyond what had been done. Legitimate expectation, I won't say much about that. Highly controversial, potential exception, probably quite difficult still. One has to look at the evolution of the TO case, both in Australia and here. I haven't got time to do it. And then finally, human rights cases. There is an exception that when considering convention rights, you may have regard to international law. And there are cases now which have begun to look at the Aarhus Convention in Strasbourg case law. I haven't got time to go through those, but there's a couple of domestic examples, the Venn challenge back in 2016, the Austin and UK case. And then if you look at the Strasbourg jurisprudence, there are now lots and lots of cases where the Strasbourg court has referred to the Aarhus Convention. Again, that's something we're going to cover in a future blog. So finally, my final thing, in Walton, in the Supreme Court, Lord Carnwath referred to a decision of the Compliance Committee and said, although the convention is not part of our law, it is not being directly relied on in the appeal, the decisions of the Aarhus Compliance Committee deserve respect on the issues related to standards of public participation, which was the issue in Walton. So the suggestion was, and it's been referred to in other cases, that although the committee's decisions are not binding, they should be given respect by our courts. I ask, is that correct? Does it risk incorporation by the back door? Is it dangerous? Because the committee is very much not a court, doesn't apply court procedures, doesn't necessarily follow, for example, European jurisprudence. There are plenty of other domestic cases where decisions have been quoted and referred to, but I would remind you, look at the Evans cases where the Court of Appeal rejected the views of the Aarhus Compliance Committee on Wednesbury not being compatible with Article 9. And I think that's an issue that Nick is going to touch back on in terms of his talk later on. So thank you very much. That covers my subject. I'm going to hand over to Alex now.
Hello, I will be talking about the 3 pillars of the Aarhus Convention in 20 minutes or less. Here is the city of Aarhus on the slide. Aarhus is an actual place, not just a lifestyle choice. And if there's one thing I want you to remember from this talk, it is the 3 pillars of the Aarhus Convention. What they are, how many there are. There are 3 pillars, not 1 pillar, not 2 pillars. 4 is too many, 5 is misconceived. 3 pillars of the Aarhus Convention, which, as James has said, are as follows. These are the 3 pillars of the Aarhus Convention on the slide. We can visualize it. On the left, we have the pillars of creation, a Hubble photograph of cosmic gas some 7,000 light years away, the crucible in which new stars, new solar systems are formed. I'm not talking about those pillars today. I'm talking about the 3 pillars of the Aarhus Convention. And we see those 3 pillars in Article 1 of the Convention set out on this slide. That's Article 1. You can see it. I won't read it. Pillar 1 of 3, access to environmental information. Would you like some environmental information? If so, Pillar 1 is your pillar. The drafters of the convention, what did they do? They drew heavily on Council Directive 9313 on the freedom of access to information on the environment. But they didn't stop there with Directive 9313. They went further, the drafters, than Council Directive 9313. Council Directive 9313 was insufficient. Hence, Directive 2003-4 came into effect prior to the ratification of the Aarhus Convention. Bit of legal history there on the 3 pillars of the Aarhus Convention. Still on Pillar 1 of 3, and we see there are 2 limbs in Article 4 and 5. You get your environmental information on request, that's Limb 1. The government needs to collect the information too, that's Limb 2. It makes sense, it wouldn't work otherwise. Can I have this information, please? No, I'm very sorry, we didn't collect it. That wouldn't work, would it? The drafters, they knew this. Still on Limb 1, requests, Article 4, you need to make a request. Your motive in making the request is irrelevant for the purposes of the convention. Maybe you couldn't care less about the environment. Maybe you even hate it. It doesn't matter. You are still entitled to your environmental information, Article 4. You're entitled to all of it, all the information, not just the government's summary of the information. Just imagine if that were the case in judicial review proceedings, all the information, but it's not the case. The information under Aarhus must be provided in the form requested. Now, that's what the slide says, so it must be true, but I think there must be limits to that. If I requested HD DVD format rather than Blu-ray, surely, you would think, surely. But on a more serious note, what if your client was blind, say, and requested an audio transcript? What if your client was a Welsh speaker and wanted it in the Welsh language? Would it need to be sent in the format requested there? What sort of limits can be placed in terms of the cost? Currently unclear. Time limits for providing the information, basically as soon as possible, but in any event, within a month. Exemptions, these are in Article 4.4 and Article 4.3. The 4.3 exemptions are on this slide. They look a bit like the exemptions under Regulation 12 of the Environmental Information Regulations, uncanny. Other exemptions, Article 4.4, fairly chunky list on this slide, but all subject to there being an adverse impact on the protected interest in question. Article 5, that's the active information gathering requirement. Gathering information, that's what this is all about. The government needs to do a number of things, needs to keep an electronic database, quite onerous, quite prescriptive, this part of the convention. There's a lot they have to do. There are also, for example, requirements about providing administrative assistance in accessing the information. Article 5.7, the government has to publish facts and analysis of the facts, which the government considers relevant and important in framing major environmental policy proposals, worth bearing in mind if you're working on or seeking to challenge major environmental policy proposals. So that's Pillar 1, the first pillar of the Aarhus Convention. It's gone, it's over. We're on Pillar 2 of the 3 pillars of the Aarhus Convention. Pillar 2 is about public participation. Aarhus Town Hall is in the photo there, not what I expected when I Googled it. And you will find Pillar 2 of 3 in Articles 6, 7, and 8 of the Aarhus Convention. Not Article 9, that's the 3rd pillar. Hold your horses. Question: are you allowing the public to participate in environmental decision-making? You're not, you say? Then you might just get a complaint under Pillar 2 of the 3 pillars of the Aarhus Convention. How does it work? Right now, it works quite well, actually. EIA, mainly, lots of consultation under EIA, lots of public participation. The public are informed, the public can respond, the public can participate through the planning process. They can read the environmental expert reports if they want to. Do they? Often they don't, but that's okay. That's not really the point. It's a right to participate, not a duty to. Sometimes the public do read the reports, they do challenge the expert conclusions, and they do make a big difference. Environmental decision-making is improved. So yes, we have a cumbersome EIA system perhaps, yes, but it works largely very well, I'd say. The public are able to participate. But for how long? EIA will be replaced, it seems. Replaced with what? A good question. Maybe the Levelling Up and Regeneration Bill will tell us. I looked at the bill, it doesn't tell us. EORs, Environmental Outcome Reports, this is the proposed EIA replacement in the LERB. It could be very similar to EIA. It could be very different. We don't know. I asked the bill, it didn't tell me the answer. The bill sets out very limited consultation rights for the new regime. We will have to wait for the secondary legislation. Might there be a complaint about this new regime to someone in Geneva, someone on perhaps the the Aarhus Compliance Committee? We will have to wait and see. So last thing on Pillar 2, almost on Pillar 3, not quite. There's also a bit in Article 6, paragraph 11, about genetically modified organisms, which I thought was quite interesting. Public participation in GMO decisions. It's interesting because there's another new bill that's almost law. It departs from European law and deregulates GMO releases, or to be more specific, it facilitates the deregulation of GMO releases. It's called the Genetic Technology Precision Breeding Bill. Does it say anything about public participation? It does not, for better or for worse. There are different views on genetically modified organisms, and there have been for a while now. That's all I'll say on that. 3rd pillar, Pillar 3, we're almost there. Access to justice. This is the courthouse in the city of Aarhus, very meta. Article 9, costs, big impact on costs in UK law. Article 9, I won't say much about this as Jacqueline will cover it. Bit of Aarhus trivia though. Aarhus was first mentioned in an English case in 2005. It was a cost decision by Lord Carnwath, who is chairing this very seminar. What does the convention say about access to justice? Third pillar, 3 flavors of justice under the convention, Neapolitan style. Depends what we're talking about as to what you get. Environmental information, you have a right to an independent review of a decision concerning access to environmental information. In the UK, that's the ICO. Permitting decisions, the requirements are higher. You can challenge the substantive and procedural legality of the decision before an independent and impartial body. Other environmental impacts, polluters, failure to follow environmental law, you have a right to administrative or judicial procedures to challenge the failure. Quite a few things I could say about access to justice. I will just note the following. Article 9.4, none of these procedures shall be prohibitively expensive. That's where costs come in. Standing, members of the public concerned. What does that mean? Does that include, say, a parish council? I think there was a permission decision on this a couple of years ago. Do you need to have participated in the decision-making process to some degree prior to your challenge? Quite possibly in the UK. In fact, I think yes, although I think we are still generally better than many European countries on standing. Query if that will remain the case following the recent trend in JRs on the subject of standing. Final thought under pillar 3 of the 3 pillars of the Aarhus Convention, substantive and procedural legality. You can challenge substantive legality. Does that align with the Wednesbury unreasonableness standard of review in judicial review proceedings? Currently, as long as the decision isn't mad, the courts won't attack the substance, substantive legality. I think Nick will be talking about this. There might be an issue, but basically so far, spoiler alert, I think the courts have already said it's basically fine. So that's it. That's the 3 pillars. We've done all 3. As I said at the start of this talk, if you remember one thing from my talk, one thing, I hope you remember the 3 pillars of the Aarhus Convention. Thank you very much.
I feel that a lot's been lined up for me to talk about on costs, but I'm going to try and cover quite briefly in the next 15 minutes or so, essentially where we've got to on cost protections in Aarhus claims. Again, I hope everybody can hear me. Please shout if you can't. Alex froze me momentarily there. I'm not completely sure if that was me or him. So if there are any issues, please just let me know. So as Alex and James have already alluded to, costs essentially fall under the 3rd pillar, that of access to justice. And there's the 4 points that Alex has already referred to under Article 9. Article 9.1, that's the information, and where it's refused, the need to have a review procedure in place to challenge that, which expressly provides that it's got to be free of charge or inexpensive. Article 2, we're dealing with the review of decisions that are subject to the other participation provisions in Article 6. That's often caught by the EIA type decisions. Article 3 is that broader access to administrative or judicial procedures to challenge acts and omissions by private persons, public authorities that contravene provisions of national or related environment. And then Article 9.4, which is sort of the sweep up, which is where we really get into the cost provision, which talks about how the procedures in the 3 paragraphs previously talked about shall provide adequate and effective remedies, including injunctive relief as appropriate, and be fair, equitable, timely, and not prohibitively expensive, a term that we will come back to shortly. Now, as James has mentioned, that point about not being prohibitively expensive is given effect in domestic law through Part 45 of the Civil Procedure Rules, 45.41 to 45.45, and it's picked up in the appellate context in 52.19a, and those provisions were essentially applied across to the Supreme Court through the Supreme Court's own practice directions. And certainly in the cost context, where we seem to have got to is that these provisions are not otherwise directly enforceable in the domestic courts. I referred there to the Venn case from 2015, which was looking at the regime as it was before where we get to now. So where there was the more limited cost protection that only applied to judicial review and didn't encompass the statutory review cases, and where the court was asked to look at that and said, well, yes, it doesn't do that, but it's also not right for this court to use its discretion to bring that protection in from Article 9.4, where there's been a deliberate decision by Parliament or in the CPR rules not to extend it to that broader group of planning type claims. And so that then was obviously pre the more expansive rules that we now have, and that I will look at in the rest of the talk. But that's still often cited as the proposition around whether you can or can't rely on Article 9.3.4, Article 9.3, Article 9.4, where you can't bring yourself directly within the letter of what's in CPR 45. Now, in terms of what claims are included, you get the cost protections in the CPR for Aarhus Convention claims, and I popped on screen there the definition of that we have in 45.41, and that's very much tied, as James has said, to Articles 9.1, 9.2 and 9.3 of the Convention. Now, it's a claim brought by one or more members of the public. Now, members of the public is to be construed in accordance with the Aarhus Convention. We also find that in 45.41. Where we've now got to is it doesn't include local authorities. That's clear from two communications that were challenging the consultation carried out by the government on the HS2 project prior to the January 2012 command paper, and the Compliance Committee said in that case London Borough of Hillingdon, which was one of the complainants, was not a member of the public. But on the other hand, community parish councils do seem to be included in that definition of members of the public. So again, there's a Compliance Committee communication on a Scottish Community Council, and there's been a few decisions kicking around sort of known about, but there isn't necessarily an easy reference point or reported point for them. But one that's often referred to in this context is the Crondall Parish Council, the Secretary of State for Housing, Communities and Local Government, which was a decision of John Howells QC sitting as a Deputy High Court judge back in 2018. It did go on to a substantive hearing that is reported, but it doesn't touch on the cost point particularly there. And the other point to pick up, as James has mentioned, is it refers to claims for judicial review and statutory review and some specified appeals, which are essentially treated as though they're a review. So those are appeals under Section 289 of the Town and Country Planning Act, and appeals against listed building enforcement notices under the Comparable Act. It doesn't apply in terms to the private nuisance claims, as James mentioned. In terms of unpicking that a little bit, there is often a common assumption: this is the planning case, therefore it must be an Aarhus case. It's now quite clear from a recent case, Lewis and Welsh ministers, that we can't just say it's this type of case or it's this type of claim, therefore Aarhus necessarily applies. As the court made clear in that case, the focus has got to be on the nature of the claim rather than the nature of the decision challenged. That kind of cut the other way to what I'm saying in that case, because what was challenged there was an outline business case for a new hospital, a new cancer centre, sorry. And part of the pushback on whether this was an Aarhus Compliance Convention claim was, well, it's an outline business case, it's a funding decision, that's not, it's not relating to the environment, it's about funding. So that was the context in which the court said there the focus has got to be on the nature of the claim rather than the nature of the decision itself. But what there needs to be is a consideration of whether the claim, when you look at it all in, is within the scope of Article 9.3. That's the issue in that case. And for a case potentially falling under 9.3, that what you need to look at is the provision of the national law, which is said to have been breached, because that's what gets you into those protections. And in that case, the court found that it was, because of the three grounds that were raised. The first was about material considerations to do with things like feasibility of co-locating the council development with the development, and a second ground was an alleged failure to carry out a clinical review of the standalone unit, but the key ground which the court focused on for the purpose of this decision was that there was an alleged breach of the duty to seek to maintain and enhance biodiversity in breach of Section 6 and 7 of the Environment Wales Act 2016. So having looked at it and actually looked at what was being raised, and this was being taken forward as a genuine and substantive ground of challenge, it wasn't just thrown in to try and bring you within the Aarhus protections. The court was satisfied that, well, yes, this is an Aarhus Convention claim, and also made the point that, well, sort of once you've got something that's an Aarhus Convention claim, it's all an Aarhus Convention claim. You don't try and divvy up costs or protections by reference to which bits might be and might not be. So essentially, the way I've summarised that is, once you're in, you're in. It applies to the entirety of the claim. You're not getting into sort of issue-based cost caps. Now, I've mentioned the words good faith. There was sort of a suggestion floating around in that case, or an argument that is this really at its heart? This is a make-weight ground. It's not really the main ground that's the focus of the challenge. The court was satisfied this was being genuinely pursued. It didn't have to be satisfied that it would definitely succeed or it was the strongest ground or anything like that. But it did leave open the possibility that the court could take the view in a different case that the ground that might get you in, or the one that looked environmental, or looked like it was alleging a breach of national law related to the environment, might just be there to try and shoehorn you into the regime. The court could take a view in that case, well, no, when you step back and look at it, essentially this isn't really an Aarhus Convention claim, even though there's something in there that allegedly said there's a breach of this environmental provision or that environmental provision. So that's sort of where we've got to now, that we've actually can't just sort of take a paintbrush and go, yes, these are all definitely in and definitely out. There is that sort of reinforcement that we need to look at the particular claim. And the other point just to flag here is, obviously it is possible to challenge whether or not a claim is an Aarhus Convention claim. There is a cost risk for an unsuccessful defendant or interested party in that situation, as the rules set out in 45.45. If the court finds that actually it is an Aarhus Convention claim contrary to an argument raised by the defendant or the interested party, then they will normally award costs against that party if the challenge is unsuccessful, and that will be in addition to the sort of default costs liability which would ordinarily apply. I've mentioned there IP because obviously the language used in the provision is that of defendant, but this has been picked up in the Kent and Teesside Magistrates Court case, where although the defendant had ticked the box saying we don't think this is an Aarhus Convention claim, they'd sort of then been neutral after that, and it really was the interested party who'd done the running on pushing the point that it wasn't. So the award in that case was made against the interested party, following on from something that was said in the CPRE Kent case of appeal that I'm going to come on to in a couple of slides. What claims are not included, as I've mentioned very briefly, it's pretty clear that you can't sort of go to CPR 4541.45 and say, I want one of those cost protection orders for my private nuisance claim. And the authority that tends to be cited for that, certainly cited in the White Book, is Austin and Miller Argent, South Wales Limited. Although actually, when you go and look at the case itself, the claim there was sort of essentially saying, I would like to have a protected costs order, and because I think my claim comes within Article 9.3, Article 9.4, as opposed to saying I want a cost order specifically under CPR 45.41 to 45. And the court, although it's cited as authority for the proposition that you're not in these regimes for private nuisance, the court sort of left open the idea that this could be relevant, 9.3 or 9.4 could be relevant or material to the court's discretion if it was considering a cost cap, considering costs in a private nuisance claim. Similarly, it's also clear that an unsuccessful, perhaps this is unsurprising, that an unsuccessful defendant who's been sued for nuisance can't then rely on the Aarhus Convention to limit its cost liability in a private nuisance claim. But again, that was dealt with in Coventry and Lawrence 2014 UKSC 46 case, often referred to as one of the number two, the Fen Tigers number two. And there were a number of arguments that were being raised in that case about the cost award that have been made in respect of the appellant's costs, including under ECHR and such like. But the court was pretty clear that no, Aarhus isn't really going to help the unsuccessful defendant in this context. And just also interesting, recently there's been a suggestion it might not apply to a challenge to a costs award made by PINS. And I preferred that to the Holton Borough Council case. This is a decision that came out first week of February, just the second week of February. And it was a bit of a procedural shenanigan, it looks like, because it had been issued as a 288 against a cost award where the decision had been withdrawn, and it'd been then the claim had been issued in time, but it hadn't been served when it was sent back to the claimant for service. So there was an application for an extension of time. There was also an issue about, is this 288 at all? Should this have been a JR? Court said it probably should have been a JR in the circumstances of that case. So they'd used the wrong form. So they also needed to apply for permission to amend to essentially use the right form. And the only point in substance that was different between the form they'd used and the form they should have used was that this requirement to specify whether something was an Aarhus Convention claim. And the court really said, well, that's not really enough of a substantive problem to think that we shouldn't just let that amendment happen on that ground. But interestingly, did go on to say, essentially, it might have been a throwaway point, but that although the only substantive difference was the form required you to specify whether it's an Aarhus Convention claim, whilst this can, of course, in some cases be important, no sensible person would think that the Aarhus Convention could apply to this claim, and the contrary is not suggested. Now, it's not clear because that's just a one-sentence sort of statement, as it were, whether that might be because looking at who the claimant was, the Borough Council, or if it's because it was thought to be a cost award and Lewis wasn't considered. But it was just something that seemed quite interesting in light of what Lewis now tells us we have to do is a cost award, something that you can maybe bring within the, if you're challenging the cost award, just the cost award, is that something that might trigger the Aarhus protections or not? So obtaining cost protection, procedures set out in CPR 45.42. The points to just note that you've got to say whether or not, if you're the claimant, you've got to say whether or not it's an Aarhus Convention claim and whether or not you want the cost limits to apply. It's an opt-out rather than opt-in, but it's important to note that there is that box that's got to be ticked. Just again, on the importance of timeliness, because this has got to be set out in the claim form. There's been a decision in 2022. Again, this was a wrong form situation, started as a JR, should have been a 289, needed an extension of time. But when they sought to amend, they also wanted to bring in an Aarhus Convention claim, and the court said, come on, there's a timing issue here. Claimants have got to file a schedule of financial resources, setting out their resources, liabilities, and of anybody who might be assisting them with costs of the litigation. And I flagged that can include monies which, or is likely to include monies which the claimant may expect to receive through crowdfunding. But the mere fact that you might get more money than you're expecting afterwards doesn't necessarily mean that your information is deficient. That was picked up in Lewis. But it could be material if the defendant wants to subsequently make an application to vary a cost limit, then or on appeal. And I've just flagged in that regard the RSPB case, although that is picked up to some degree now in the rules. Now, in terms of the cost limits, CPR 45.43, default where 5,000 were seasoned individual, 10,000 otherwise, which obviously include your public interest groups, 35,000 default for D, can be varied. Just 3 points to flag on these. Firstly, just to make clear that the limits apply to individual claimants or defendants, regardless of the number of other parties who might want to draw on their cost window. And the costs limits are inclusive of that. And that's the Court of Appeal decision in Friends of the Earth from 2021. I'm aware there's another case floating around at the moment where the parties sought to change, I think something had been agreed in a costs consent order on the cap, which said cost plus VAT. And that was pre the Court of Appeal's decision in Friends of the Earth. And I think that might be on appeal at the moment. So there may just be a watch this space. But also just to know that you don't have the default limits specified on appeal in 52.19a. So it's a bit more up to the court's discretion. In terms of varying the default limits, I've set out on the next couple of slides procedures that have got to be followed. The key test is obviously the whether or not it would make proceedings prohibitively expensive for the claimant. But the key point to flag in terms of points to be aware of is that although the language that's used in the rules is that the defendant can make a variation, it's now accepted that a variation application can also be made by the interested party. That first came up in a case of Bertoncini in 2020, relying on something that was said by Lord Justice Coulson in the CPRE Kent case. It's not one of the ones that's been ticked as saying, yes, you can cite it, but it's cited in the White Book. It seems to be being picked up in various cases, so that's sort of where it started. And obviously an application to vary the default limits can be made afterwards if there's been a material change in circumstances. And this is picking up on the point that was in the RSPB case from 2018 that I mentioned. But again, the key points here are the prohibitively expensive point, and just to note that any applications will be heard in private. Prohibitively expensive, we've got a long list of things we need to look at in CPR rule 45.443. But just to highlight that although the language says about the likely costs, including any court fees payable by C, being prohibitively expensive, the court did make clear in the RSPB case I referred to at the bottom of the slide in 2018, which is on the predecessor rules, but which still use that language, that when you're considering whether proceedings can be prohibitively expensive, the court may properly have regard to the claimant's own costs in bringing the claim. So just something to be aware of. And just finally, 2 quick points to pick up on assessing costs. Firstly, in CPRE Kent, now this is the case that's better known for the Supreme Court's confirmation that interested parties can expect to receive their reasonable cost of acknowledging the service as well as defendant in a planning JR. But at the Court of Appeal, the grounds were argued were wider, and one of them was about the relevance of the fact there was an Aarhus cost cap in that case. And 2 points particularly came out of the Court of Appeal's judgment on that ground. One is that you don't have separate caps of permission and substantive stages. So yes, you can have an award that goes all the way up to 5,000 or all the way up to 10,000, even at the permission stage. You don't assume that 5,000 or 10,000 is how much the whole claim ought to cost. So the court must be looking at something lower as an award of cost at permission stage. And secondly, linked to that, there's no difference in the usual approach to summary assessment of costs. Essentially, you carry out the usual exercise. What would be a reasonable proportionate amount of cost to award to the dependent, the interested party? And then if the 5K comes in somewhere below that figure, well, you know, that just means that the defendant and interested party don't get all of that, which is thought to be reasonable and proportionate. And the other point, just to flag, because of this theme that's floating around in other contexts about what degree can you rely on Aarhus. In the Richardson Environment Agency case, which was the Staffordshire landfill challenge from 2021, with a young child with particular medical conditions being affected by hydrogen sulfide emissions from a landfill site, that might look like sort of an almost an obvious case to be an Aarhus a cost case, but actually a cost cap wasn't claimed in that case. It may be because the claim was legally aided, I don't know, but it wasn't. But in that case, actually, Mr. Justice Ford, and when he was looking at quantum and proportionate costs, essentially said his order wasn't influenced in any way by the EA's reliance on the cost cap in the Aarhus claim and the 35,000 default liability that would have been expected had the cost cap been applied for and applied. So with that, I'll hand on to Nick for outstanding communications for the Compliance Committee.
Cracking. Thank you very much, Jacqueline. So, as Jacqueline said, I'm picking up with the current open complaints against the UK. I'm specifically focusing on the UK for, I hope, fairly obvious reasons. 2 broad caveats. First, as these are open and ongoing complaints, and particularly as James and I are involved in a couple of them, I will not be providing any searing legal analysis as to which ones are right and which ones are wrong. You probably wouldn't get any searing analysis from me anyway, but at least this time, or for this reason, I have an excuse. The second point by way of caveat is each of the complaints and all of the various submissions that have been made are intricate, detailed documents, and all I can really do is provide a high-level summary. So if anyone on this call is involved with them, I mean absolutely no disrespect if I'm simply summarising points or leaving some out of account altogether. But with that in mind, there are 4 open complaints against the UK. They focus on the EU withdrawal bill, the utility of Wednesbury, the UK's approach to free trade agreement negotiation, and planning appeals in Scotland. There's also as we'll blog on this later, an ongoing complaint against Ireland. It's at the pre-admissibility stage, so the committee hasn't decided whether it's going to accept it or not, but it's just, I think, of interest because of some of the points that they raise, one of which is, for example, that the time limit for JR should stem from the date the public is notified of the decision, not from the date of the decision itself. And certainly we've had in this country a recent claim caught out on that very point. So I will pick up then with the withdrawal bill complaint. The main communicant here is Friends of the Earth, and it's alleging breach of Articles 3 and 8, which, thanks to Alex's excellent presentation, I think I don't need to go over. But in a nutshell, what's being said is that it's a breach of the convention that the government didn't consult on the draft text of the Withdrawal Bill 2017 before it was introduced to Parliament. The stage we're at is that there's been extensive written and oral submissions over the last 5 years. The committee heard oral submissions at its last meeting in September, and so we in the UK eagerly await a decision. I'm going to pick up primarily on the application of Article 8 because it is the most interesting, I think, aspect of this claim. So I've put Article 8 up on your slide. The dividing lines between the parties are basically these. The complainants or the communicants, Friends of the Earth, suggest that primary legislation clearly falls within the definition of generally applicable, legally binding normative instruments. They also say there'd be really quite a lacuna in the legislation if the government had to consult members of the public on things like statutory instruments, but not on primary legislation, which is, of course, where the big changes get made. The government's response in a nutshell is that Article 8 doesn't apply to primary legislation. If you look at the way this particular bit of Article 8 is worded, both the heading and the text, what it bites on is executive regulations. And the government said that generally applicable legally binding norms is wording that's been inserted to effectively ensure that parties can't get around the protection by saying, oh, it's not a regulation, it's an order or something along those lines. But what it's crucially biting on is effectively secondary legislation, not primary. This follows, the government says, both from the wording of, as I said, Article 8, also from Article 2, which is provides the definition of public authority, which is on what Article 8 bites, does not include bodies or institutions acting in a judicial or legislative capacity. And it said that you would effectively be infringing the legislative process if you were going to start setting out very clear requirements for consultation in advance. At the end of the day, a bill is introduced and it goes to Parliament with something like a statutory instrument. Of course, the government promulgates it, it drafts it. There's usually, yes, some sort of procedure in one or both houses of Parliament, but it's nowhere near the same as the kind of legislative debate and discussion that gets had for primary legislation. So in a nutshell, the government says, no, it doesn't apply. The jurisprudence on this is mixed. So the Slovakia decision that's on the bottom of your slides is a case where the committee did say that Article 8 applied to primary legislation, but in that case, it was conceded by Slovakia. In fact, it had been conceded by their Supreme Court and their government. So it wasn't really argued, certainly not to the same extent that the point was argued in the Brexit, in the withdrawal bill case. And there's also a decision of the CJEU on this particular point in Flaklas Torgau, which is a pronunciation I'm sure I've just completely mangled. And both sides say that case basically supports each individual view. So it'll be fun to see what the committee does with that. There is a bit of an overlap between the Flaklas Torgau case and the current incarnation of the Compliance Committee, because Advocate General Sharpston was the AG in Flaklas Torgau and is now on the Compliance Committee. So we'll see what happens. The second key issue is, if it does apply to primary legislation, does it apply to this particular bill? And that turns on whether it was a piece of legislation which may have had an environmental effect. Now, the communicants say the bill definitely would have done. We're talking about the bill that effectively decoupled the UK from the EU. So they say it reduces the protection provided by treaties. It removes the Commission's role. It allows a departure from the EU legislative scheme and indeed any environmental developments in EU law, and facilitates regulations which would depart from EU law. The government's response is much simpler, and basically it says the policy of the bill as it was drafted and introduced, is specifically not to make any changes, not in the substantive law. If anyone's had the joy of reading the explanatory notes, that's up there pretty clear. I think it's paragraphs 10 and 14. So any future changes are for future communications. That's a different question. That's a different kettle of fish. So the government's position is no, it doesn't apply to the withdrawal bill. What's going to happen? We'll wait and see. The next case that I want to talk about is the Wednesbury case, another case from 2017, or at least the communication was made by 2017, brought by Friends of the Earth again, the RSPB and Lead Day. And it's a breach of the alleged breach is Articles 3 and 9. But basically, the nub of it is, as Alex has helpfully teed up for me, an argument that the Wednesbury standard of review does not satisfy the UK's obligations. And what's said, in short, is that it's just too hands-off. It doesn't allow a review of the substantive legality of the decision. And some examples are given throughout the communication, including, for example, the fact that decision makers rely on expert reports procured by the developments, and the courts then take and courts generally take a hands-off approach in assessing the evidence. It's alleged, whether you agree with this or not is a different question, but it's alleged that Wednesbury review extends very little beyond an examination of procedural legality. So actually what the public cannot do is challenge the substantive review of the decisions. The obligation that we see on decision makers to have regard to consultation responses isn't as exacting and demanding as, for example, the obligation to have due regard that you see in, for example, the public sector equality duty. And in our current scheme, one decision maker is allowed to rely on decisions of other decision makers. So, for example, as we commonly come across in planning applications, a committee can assume that subsequent pollution control regimes run by, for example, the Environment Agency will act effectively and competently. All these points are subject to challenge, and effectively what's set out in the communication are some suggestions for how a compliance standard of review, it is said, could be reached. I've listed them on the slide. I won't go through it, but effectively it's putting a much bigger burden on the courts to really roll up the judicial sleeves and get into the weeds of the evidence, as far as I can see. It's phrased in space such as the court has to satisfy that X and Y was properly considered, actually evaluated the information or evidence, but effectively what it is they want the court to get a bit more involved and be much less hands off. In fact, the communication goes so far as to suggest that it might be time for environmental decisions not to be subject to review by the administrative courts at all, but by a specialist set of environmental tribunals who feel more comfortable getting involved in doing exactly what's being sought. The government's response effectively is that it doesn't accept, well, it doesn't accept that Articles 9, 2 and 3 and 4 concern the substantive rules of law. Those are talking about access to the courts and tribunals or remedy procedures. But even beyond that, they say that the characterization of JR or statutory review that's outlined in the communication is just not right. It does go beyond procedural review, and that's why you can, for example, review on basis of errors of fact, misunderstanding evidence, insufficient investigation, and immaterial consideration. And I think the government cites a number of cases where environmental claims do succeed. Now, obviously, the communicants have expressed some dissatisfaction with that. Again, there was a hearing on this some time ago, now a number of years, and we await the outcome. The next two cases I can take slightly more briefly, because the stage they're at is we haven't had the government's substantive submissions yet. So the complaint has been made, the committee has decided it's preliminarily admissible, which means they're not going to kick it out as manifestly ill-founded, but the government has yet to actually introduce its substantive response. And the first of these is the free trade agreement case that came in this year. The complaint is made by a coalition of 8 NGOs, but the primary, I should say primary contact, not contract, is WWF's head of legal. Again, it's an argued breach of Articles 3, 1 and 8, but in a nutshell, what's said is that the steps that the government goes through for undertaking public engagement while negotiating free trade agreements are insufficient. It said that FTAs fall within the definition of Article 8 of generally applicable legally binding rules, which may have an environmental impact. And it said that that impact may arise through, for example, offshoring environmental harm. You move the pollution to another country, eroding environmental regulation, because of course you've usually got some sort of supranational court or arbitration regime to say if there's a breach of whatever the trade agreement is, and regulatory chill. The concern is that the Environment Agency or other regulators will be concerned about putting the UK in breach of its obligations, and so they will enforce. The current arrangements in which the coalition of communicants rely for communication and saying these are insufficient are set out on your slide. So the government consults on its negotiating mandates, it seeks to update the public, it does establish stakeholder engagement groups, it publishes the final text of the FTA, and it publishes an impact assessment. But all those steps cumulatively, it is still said, are insufficient. So consulting on negotiating mandates is one thing, but the government does not, for example, then consult on the iterative text as it goes through. Updating the public is one thing, but the government doesn't have any obligation to take public concerns into account. And the stakeholder advisory groups are generally not, it is said, open to the public. So 4 issues. 1, does that Article 8 apply to FTAs? Actually, are they generally applicable legally binding norms, particularly in our dualist system, which James talked about at the start? 2, and these are, I should say, are the issues as set out by the communicants. I'm not summarising them. 2, what effect of a free trade agreement is there once it's been concluded but not, say, implemented or ratified? And then 3 and 4, are the minimum requirements of Article 8 met, and what's the relationship between Article 8 and parliamentary scrutiny? We'll see what happens. The last case concerns Scotland, and it concerns a regime that will be familiar to everyone in the UK. In fact, it's basically what's being challenged is this 2-tier system in planning decision making, where if you are a developer and the LPA refuses your planning permission, you can go to the Secretary of State, and the Secretary of State issues a new decision. If you are a interested party or a local council, so not a local council, if you're an interested party and the local council grants consent, then you are limited to statutory review or JR. And what's said basically is this is fundamentally unfair. You've got a 2-tier system that's privileging developers, and that is said. I know we've had Article 9 a lot, but if you look at Article 9.4, the procedures referred to shall be fair. That's in the 3rd line, and it said that it's just not fair. The committee has considered something similar in England and for the system in England and Wales back in, it's a 2013 communication. I can't quite recall when the decision came out. So it'll be interesting to see what it does in this case. Of course, planners might be thinking this kind of mischaracterizes it, because the system, because when you go to the Secretary of State as part of the decision-making process, it's not actually a review of the decision. You're not questioning the substantive or procedural legality of it. This is part of the actual decision-making, not the review of the decision-making. But we'll see what the committee goes with, and we'll have to see what the government, whether the government deploys that line of argument or not. I don't know. So that's pretty much it from me. As I said at the start, if you've got any questions, by all means, stick them in the chat box. Otherwise, I'll hand back to Lord Carnwath.
Yeah, yeah. Sorry, I'm trying to get my screen back on. I think we've got one question which I'll just come back to. I'd like to ask you a sort of question of my own, because I think James Maurici was perhaps winding me up a bit when he's referred to my statement that the Aarhus committee decisions are entitled to some respect. I thought that was a fairly innocent remark. But it'd be helpful if someone, perhaps James in the first instance, could just say a little bit about
Well, I mean, it's several things. I mean, I think obviously that's the current personnel. They're not a court, and they emphasise very much they're not a court, and they don't decide things in a court-like environment often. They are pretty clear that they don't themselves feel obliged to follow decisions of the European Court or domestic courts. And in fact, although almost all of the members, I think, are lawyers, they don't even have to be lawyers. And the reality is that I think some of the decisions that have been made over the years are pretty extraordinary interpretations of the convention. The whole system is very. It was set up to be critical of government, to build NGOs into the system. So NGOs from around Europe get a kind of, they've got a right to be there at all of the meetings and to make representations on other people's cases. So the kind of it has a kind of very NGO focus, which is understandable in all itself. But I just think that one has to be careful about what we take from the decisions that they make. I think that Wednesbury is an interesting one. They've been critical of Wednesbury before. I didn't feel the previous committee who made those comments understood Wednesbury and how it works in our system. I hope now, with that decision hasn't been issued in the main case, you've now got, as you say, Sharpston on the committee. There are actually now 3 lawyers on the committee currently who are from common law jurisdictions, yes, which is the most ever.
James, I got your point. Does anyone else want to comment on that? No, I don't think so. Now, we have got a question from John Van Nuffel, I hope I pronounced it right, about traffic regulations order. Well, the ouster clause, which prevents you challenging a traffic regulation order outside 6 weeks of the order being made. And he poses a question of where the publicity requirement has not been met and no notice or signs have been placed for 6 months. The public are denied the opportunity to challenge, assuming the regulation order is made for an environmental purpose. Might Aarhus be engaged to provide an opportunity to challenge that? Who would like to comment on that? Well, I'll try Nicholas.
I could ask a sort of different question. Probably I was going to ask Nick or James anyway.
Alex.
Would that not apply to the sort of the 6 week time limit in planning generally? And I wonder if has there been a challenge yet to the committee saying that 6 weeks isn't enough time to challenge an environmental planning decision? I don't know the answer.
I don't think there's not been an actual decision that's come out, I think, but I mean, obviously, we've looked at this in domestic law. Griffiths' decision in the House of Lords, where Mr. Griffiths didn't get his planning decision from the inspector until after the 6 weeks, and he was debarred. And there is a more recent Mr. Justice Sullivan decision that looks at this from the perspective of whether it's a breach of Article 6 of the European Convention on Human Rights. I think that there might be a case coming that looks at the time limits. I think Nick may have mentioned that, or someone else mentioned it, but maybe you, Alex, who mentioned it. But I don't think there's anything definitive on it. Yes, Aarhus is another route to argue about that, but obviously time limits in themselves can't be incompatible. But the question is whether that's reasonable, given its shortness, and if you're not notified.
Nicholas, do you want to say anything?
What I don't recall there being a specific decision on the 6 week limit. What I'm currently doing is I have a tracker of all the Aarhus cases. And I'm just going to check it, frankly, but I might not have an answer by the end of this talk, which rather reinforces the point that James said at the start, which there isn't as much of a current awareness thing for the Aarhus Convention as perhaps there should be. And whilst all the decisions are online, they're not necessarily easily searchable or digestible. So that's what the blog is for.
So there is a challenge to bring then, by the sounds of it.
Yeah, get drafting, Alex.
Right, thank you for that. There's a question, sorry, my cough, from a Denise van der Merwe, who thanks you all, but asked to what extent is the Aarhus Convention then projected to be incorporated into more formal law? As she says, it seems that most, like the court group, the Aarhus is more based on cases for the guidance of implementation. Is there any prospect of more formal law? Can anyone say?
I doubt it. I mean, obviously, even the EU failed to adopt a more general regulation that incorporated Aarhus across the board. One of the reasons the EU failed to do it was the UK objected to it. So they might do it now. I think that is back online in the EU, but in the UK, I cannot see any likelihood of the government doing more to incorporate the Aarhus Convention. I mean, I might be wrong, but I can't see more happening myself.
Yes, there's a question from Mark Sullivan about the HS2. He says, of the 3 pillars, access to information, especially public participation, were not delivered. There was a single route published without consultation on alternatives, and it was imposed. The judges did not find the procedures faulty, apart from Jeremy Sullivan. Procedures for the previous high-speed lines both enable extensive participation on routes for the lines and result in good schemes now built. Post Aarhus, how did the government get away without offering public participation on the HS2 alternatives?
Yeah,
well,
I mean, HS2 went to the Compliance Committee and it was successfully defended by the government. Jacqueline and I acted for the government, and they found that the process that had been followed, including the extent to which alternatives were considered in documentation, had been acceptable. So not easy to win a case at the Aarhus Compliance Committee for government, but that one we did win. So
does Jacqueline want to say anything about that?
No, just I do recall, though it was a long time ago that we argued it, and it took a while for the decision to come out, that the focus very much, certainly by the time we got to the oral hearing, was on the treatment of consultation on alternatives, particularly the alternative to the Y route. So that was quite squarely the complaint that the committee were being asked to consider it in that case.
While you're on, Jacqueline, could I ask you a point which comes up in your context, I think, which to what extent can a defendant seek to get Aarhus protection? I mean, as I understand, it might be relevant if you have a legally aided claimant who doesn't need protection, but the defendant might benefit from having his or her costs capped. Is that possible?
Well, I think the short point is that it simply doesn't seem to be provided for at all in the rules. And I think probably looking at the reasons why the protections were introduced and the fact they're meant to be there to protect the claimant, that's not surprising. I mean, I'm not aware of any situation where a defendant has been able to successfully say this should be an Aarhus Convention claim and there should be a cap, even though the claimant hasn't asked for one. The power is very much given to the claimant to decide whether they want to opt in or opt out. So it's the sort of thing that's just started floating around, I think, a little bit in the ether about. I think very, very much when people are advising, it tends to be, oh, it's an Aarhus Convention claim, so cost liability will likely be capped. So that means if you're unsuccessful as a defendant or an IP, you probably wouldn't recover, you'll be limited to this. But if you're successful, you wouldn't expect to recover more than that. But I think it can occasionally take people a bit by surprise, particularly maybe when you're looking at public authority or local authority defendants. If the claimant doesn't seek a cost cap, then suddenly that sort of, well, the liability is probably only about 35 plus our costs. It sort of falls away a bit. So it's sort of on my list as a kind of a maybe watch this space a bit. Is it possible that this might be raised to get a future consultation? But I would be surprised if we see a change, given that the stated purpose of this is to protect people who want to bring challenges to decisions as opposed to those who wish to defend them.
Right, but I think we probably run out of time. There's just one point I'd like to ask generally, which you haven't covered, which is the current sort of EU retained law bill, which, as I understand it, seeks to sort of tear up a lot of European legislation if it's not specifically approved. Does that have any effect on the Aarhus Convention, or is that a completely different issue? James, do you want to?
Yeah, I mean, I think it potentially does have an impact, because I think a number of the ways in which the Aarhus Convention currently is given effect in our law is through retained EU law, as I discussed in my talk. So potentially it could. I guess it depends how much of the law is really ripped up and how much of it is actually saved and extended under the retained EU law bill, in which case the only change is that retained EU law will be called assimilated law, and actually the content of the law will be broadly the same. But you don't get much of a clue really from the substantive provisions about the extent to which that will happen. I mean, so potentially it could, but I don't think it necessarily will affect the way in which IEs apply.
Right. Well, I think on that note, we'll have to finish at 6:30. Thank you all for your presentations, and thank you for our participants to listening in, and I hope they will follow the blogs as they come out. So I think we'll end it there. Thank you very much.